Okay, it is 8:30 and welcome to week 10, the last lecture for the quarter fall 2017. And I told you that the quarter would go pretty fast. The quarter officially ends a week from this Friday, which is the 15th at 11:59 p.m. Central Standard Time. And so anyway, I'm going to uh, go over the assignments coming up. I hope that you have submitted your final report that was due week 9. And if you submit it now, unless I've made previous arrangements with you to submit it, you will be docked some points for it because it was due Sunday. It was due Sunday by 11:59 p.m. Central Standard Time. So in the meantime, let's go ahead and get started tonight on what we're going to talk about. Okay, reminding you again that this week your state's waiver, you get 10 points for explaining, 10 points for providing the exclusion of other mandates, and 5 points for APA. But you also want to make sure that you have citations and references, that you don't get hit with a grammar hit. Most of you have not had that problem. Make sure you have citations in the body and references at the end. Don't just one citation in the paper. And please do not use the textbook as your sole source. Most of you haven't done that. A few of you have. And so you want to make sure that you do that, because in addition to these 25 points, you could lose 2 points for just using the textbook. Okay, and then your discussion posts. So as you can see, you have your last lecture taking place tonight, week 10. And then again, I have lectures because I didn't do one week 2, so I did 3, 4, 6, 8, and 10. So you want to make sure you check those out if you have any concerns about your project. I've gotten a few messages from people about that, but we're past that now. So now let's take a look at this week. We're going to talk about juvenile offenders, and you're going to section 13 of the text, and then deal with the activities juvenile justice system, historical perspective. We're going to take a look at that briefly. Then your discussion assignment, the role of the juvenile probation officer. Your initial post was due Tuesday night, last night at 11:59 p.m. Central Standard Time, and your reply post is due Saturday. Finally, you have your written assignment that I just went over with for a few minutes ago. And make sure you have the proper amount of pages. Your quiz, the last quiz that you'll do for the quarter. And then I hope that you will finish strong. So let's take a look at the course calendar. And you can see that it follows up with what I said already. And then your quiz and your written assignment. Notice that with your written assignment, 2 pages. It's a requirement of 2 pages. And it is due on Sunday. And then finally, for your next week, you'll notice that your initial post is due still on Tuesday for week 11. Your reply post is due on Friday, not Saturday this time. Then you're written, and then you have your final exam. Your final exam that takes place as well. That's next week. The quarter ends at 11:59 p.m., so you will have needed to have completed these 3 items by 11:59 p.m. Central Standard Time on next week. And you know how the final works. The final works dealing with the last half of the course to help you prepare. Okay. So let's take a look at, before we do chapter 10, let's take a look at 11 again, reminding you of the assignments. These are due next week. 1 to 2 page paper that's due on that 15th. That's for week 11. Your discussion post, initial post is due Tuesday, next Tuesday. Then your reply post is due Friday the 15th. Then your final exam, 40 multiple choice and true-false questions. It's a 40-minute exam. It is timed. You'll only have one chance to take the exam, and so you want to make sure that you abide by the academic misconduct policy. You don't want to have papers in front of you and stuff like that. You shouldn't be doing that. That is improper. It operates on the honor system, but your grades usually are determined by how well you do on the test. So what's the best practice? Study before the test. So now let's go back to this week, and again repeating the assignments, and conduct research to determine your state's process. Remember, it's a 2-page paper. There it is right there. Tells you right there, 2 pages. And I also showed you that a few minutes ago. So you want to make sure you satisfy that requirement. You will lose points if you don't complete that with 2 pages, not 1 1/4, not 1 3/4, but 2 complete pages with citations and references. Then your discussion post, then your quiz, the last quiz of the quarter before your final exam. Okay. So now let's take a look at lesson content. So we'll talk about the juvenile offender. What is juvenile? What is it all about? Why? Again, these are the assignments. So let's for a minute talk about the juvenile justice system. As you should really realize that the juvenile justice system derived from England with the concept of parens patriae. And what that really literally means is that the court steps in the place of the parent and deals with the child or juvenile offender as a child. You are adjudicated, you are not prosecuted, and your juvenile record is different from your adult record. And so what the idea is to protect the children and to give the children a chance to be corrected so that they will have success as adults. Now, the juvenile system is similar to the adult system, but the decisions are made on the best interest of the child, what is best for the child. And it begins with not a summons or an indictment, but with what we call a petition. Juveniles are taken into custody. They are not arrested. There is no arrest of juveniles. Taken into custody. They are detained, but not jailed. Now, the purpose for the terminology difference is because of the intent of what the juvenile system is, and that again is to correct those individuals, to give them a second chance, prepare them so that by the time they become adults, that they won't be become hardened criminals. Adjudicated, not found guilty, and then given a disposition. There's a disposition and not a sentence. So again, the terminology, some people might say, well, equates to the same. It is not, because the goal of the juvenile justice system is to do what you would do as a parent to a child that does something wrong. You want to redirect them and help correct them. Probation is often ordered for an indefinite period, and there are juvenile probation officers. They operate pretty much almost the same way as adult offenders. Investigation and report are often done prior to determining disposition. Juveniles are also classified by their risk and what their needs are that need to be addressed by the court. And case plans are developed to determine what kind of services that would benefit that juvenile or youth. Juveniles report to a probation officer. However, the juvenile probation officers work very closely with the family itself to try to keep that child on track. Juveniles can be placed out of the home for numerous reasons. Residential placements such as group homes or in boot camps, wilderness programs, and even secure detention. The key thing is to put the youth in an environment where that youth can be redirected. Boot camp gets the youth to the point of respecting authority and learning how to follow rules and gives them some structure. The wilderness programs take them out of often areas where they're familiar with, like the urban areas, and into areas where they have to cope with things that they take for granted that they have, and those are taken away. It's not inhumane, but it's like Boy Scouts. We were taken out to camps and places like that. And then secure detention is the last place. That's like we call that the juvenile detention center. We don't call it jail. We don't call it prison, but it's a detention center where you are kept in a housing situation similar to prison, but there's more programs that are presented to you. Treatment and education is really the primary things that we want to do to try to help these juveniles that are placement. Non-residential programs are those where the youth remain in the home, but they receive education, treatment, and other services in the community itself, such as participate in community groups, things of that nature. When a juvenile offender does commit a serious offense or heinous crimes, they can be presented to adult court by a waiver process. And most jurisdictions have waiver process. You had to do assignments earlier about your juvenile waiver, and you indicate how the process works in your jurisdiction. The waiver process differs in various states, but the result is that sometimes things are pretty tough. Adult sanctions, including prisons, now apply. And the reason for that is because when a juvenile is put into the adult court, they are not put in with the adults, but they're put into an environment that's closer akin to prison. And it creates a situation where that juvenile is almost treated as an adult. They're still adjudicated. But the point of the matter is that the way they're treated is closer to the way that you're treated in prison as opposed to juvenile detention centers. The issues of youth and adult prison include many problems because of the fact that there are a lot of offenses now that are taking place where juveniles are committing serious crimes, resulting in overcrowding in the facilities, violence because of the gang activity, and then sometimes exploitation by adult offenders. Again, the key is to try to um, segregate them as much as possible from adult offenders, because what adult offenders do is they use these young um, persons and turn them into individuals they can commit crimes for them. Oftentimes juveniles are incarcerated because they're doing something that an adult, if they did it, they would receive more time. So that exploitation can continue if exposed to adults in prison. Research continues, and many states have what they call intensive community treatment and programs, where it's tough. It's very, very strict, very regimented, and you'll find house arrest, for example, and electronic monitoring options where the individual has um, a monitor on them, and every one of their moves are monitored by the probation department to make sure that that person is where they need to be at the time they need to be there. So that's kind of the juvenile system in a nutshell and how it operates. Let's go to a historical perspective of how the rights have changed and how the courts have ruled on cases that involve juveniles. Starting from 1966, and I will click on that, when a case called Kent versus United States, in which the courts stated that due process in transferring to juveniles to adult systems must take place. In other words, there must be a hearing that it takes place, giving them an opportunity to respond and present cause why a juvenile should not be transferred to the adult system. Because, as I already said earlier, it's more structured, and it usually occurs with the very serious offenses. So Kent versus United States stands for that proposition, and it's a landmark case. In 1967, in re Galt, in that hearings could result in commitment to an institution, juvenile have four basic constitutional rights: the right to timely notification of the charges, the right to confront the witnesses, the right not to testify or against self-incrimination, and the right to counsel. These are the rights that were established in the Galt case in 1967 that created things that from this point on that juveniles were entitled to receive. The next major case came in 1970, in re Winship, in which delinquency matters, the court has to prove its case beyond a reasonable doubt. So the standard is the same as in criminal court, is that in juvenile justice, juvenile courts, that individuals have the same protection that they have in adult court, but then that the standard is not a preponderance of the evidence, but beyond a reasonable doubt, a very high standard that the prosecution must meet in order to adjudicate that individual and find them delinquent. McKeever versus Pennsylvania deals with the statement that jury trials are not constitutionally required. In adult court, we already know it's a constitutional right, but in juvenile court, there is no constitutional right to juries, and juries don't take place. And one of the reasons is because of the fact that the goal, as I said, is parents patriae, to deal with the child. They don't want to have jurors to determine whether or not the individual committed the offense. They leave this all in the hands of the court system with the judges, the lawyers, and then we go from there. But no jury trials in juvenile courts. As of 1971, that was made clear. Breed versus Jones, waiver of a juvenile to criminal court following adjudication in juvenile court constitutes double jeopardy. So let's say, for example, you can't be tried in the juvenile court and tried in the adult court. So you can't be tried twice. So the waiver of the juvenile to the criminal court proceeding, criminal court, following an adjudication for a juvenile, if you try to prosecute them again, you can't. That violates and kicks in double jeopardy, which is only fair to juveniles since it applies also in adult cases. The next one, 4 years later, 1979, Smith versus Daily Mail Publishing. The press may report juvenile proceedings in certain circumstances. However, be aware of the fact that the press is allowed to, they have to redact information. They can't give the name of the person and those kind of things. They're very protective, the courts are, of the identity of the individual. That's why you'll see Doe, or you'll see an assumed name, but you won't see the name of the juvenile. Okay. In 82, in Eadings versus Oklahoma, a defendant's youthful age should be considered a mitigating factor in determining whether to apply the death penalty. So here's the deal. Here's what has happened, though. And you're going to see this coming up in just a little bit. We have already solved the issue of juveniles as far as the death penalty is concerned. And at this time, it was a mitigating factor. However, though, later on, you'll see in a few minutes that has changed. In Shaw versus Martin, preventive pretrial detention is allowed under circumstances. In other words, the individual can be held without release, depending on the circumstances of the seriousness of the offense, depending on whether the individual is a flight risk or is not likely to appear for their hearings. Thompson versus Oklahoma, the minimum age for death penalty is set at 16. Again, when we get here, Roper versus Simons, the minimum age for the death penalty is now 18. So what does that mean? That means that the Roper case stands for the proposition of what I was talking about earlier, that we do not execute juveniles. We do not. If a person commits a crime, and it's based on the time that the age at the time of the offense, if the individual is 17, then they cannot, if they have not reached their 18th birthday when the offense is committed, then they are considered as a minor, and no matter how serious the offense, they could receive a life sentence, but not the death penalty. Jurisdictions that have the death penalty. So those are some of the historical things that have happened in juvenile court. And so we conclude with dealing with some of the terms. We already kind of talked about this. Parens patriae, in which it means that a Latin term established the right to intervene in the lives of children in their monarch. Again, that carries over into the courts today, where the court operates as parents over the children, and that's what that means. So when you see that term, juvenile delinquent, minors who violate criminal law, who are incorrigible, truant, or runaway. Those are what we call juvenile delinquents. Status offender. A status offender is a juvenile who engages in behavior that is illegal only because at the time they committed based on their age. Community treatment. Efforts to provide care, protection, services, and treatment to juveniles in need, such as probation, counseling, and restitution. These are things that are essential in dealing with the juvenile. That's where community treatment comes in. Institutional treatment, facilities operated by the state or the county to restrict the movement of residents through staff monitoring, lock exits, and interior fence. So it's a big juvenile detention center, basically, is what they're talking about, as opposed to house arrest. Residential programs, places utilized by social service or corrections, such as group homes, family group homes, wilderness programs, or boot camps. That's what we refer to as residential programs. Again, remember the idea is to redirect that individual. Non-resident programs, programs for offenders that do not confine them overnight. Aftercare, the equivalency of parole in the adult system. So what happens is that the individual finishes their term outside of the facility that they are incarcerated, and they still are under the care of a probation officer or parole officer, someone who watches over them. What is a judicial waiver? A judicial waiver is the intake personnel, so that when prosecutors or judges have to make a decision whether to try the individuals in adult court. So that's when we get into the waiver system that we talked about earlier. Social investigation report is equivalent to the pre-sentence investigation. What it is determines what that individual's background is, the history of that person, to help determine how to adjudicate that individual. Statutory exclusion, laws in certain states that automatically transfer juvenile offenders to adult court for certain offenses. So if you commit a certain offense, there is no waiver issue, automatically transfers you. It has to be a very serious, very serious offense to fit into statutory exclusions, and many jurisdictions now are heading that direction because juveniles are engaged in some very serious offenses, and that's so you want to make sure that you keep in mind those terms as well. So the idea of the juvenile system is to redirect the individual, to help the individual as much as possible so that the individual is able to be salvaged. And that's it for this week's lecture. I do want to let you know that I hope you enjoyed this quarter. I hope that you learned a lot. I hope that you learned a lot from your report that you did for your project, because and you know, again, for many of you, some of you didn't get the point that this is a corrections course. Therefore, the topics were jail, prison, probation, or parole. Some people want to do law enforcement and police, and I reminded them constantly, as I did from week 1 and weeks following, that the requirement for the course is that you had to do it on one of those 4 areas, because we're dealing with corrections, which takes place after law enforcement. So that's all I have for tonight. If you need to reach out to me, feel free to reach out to me with any questions you may have. I had a few students to try to reach out to me and ask me, was it possible to pass this course? And I explained to them The same thing I said during week 1. I said the way you pass this course is complete the assignments, complete them timely, and if you run into adverse situations, let me know immediately. You don't wait until weeks have passed to try to do catch up. And then when you submit your assignments, submit them doing the best you possibly can, so that the only points you can possibly lose is for lateness. It is too late to submit through 7. You can only, at this point, submit week 8 or 9, and then you know we're in week 10 now. So that's about it. Again, you know the rules about reaching me that I've established and laid out for you since week 1. So with that, I'm going to say good night.